I'm going to be opening on children in seclusion. Really, for this topic, the biggest thing I can emphasize on anything is to listen to the child also, because in a lot of things that I've seen, it's the adults that are taken into consideration, because they're adult, they might know better. You know, adults know all in some cases, but I was in a very abusive group home for 4 years, in which that I kept telling them what was going on, what was going on, what was going on. And it was never really, I guess it never clicked in the head, because the foster mom, everything that I said wasn't right, it was all on me. That's why I have really bad self-esteem also, is from the emotional scarring that was created in that home. Even to this day, I'm very terrified to run into this family. I've seen them around town, I just freeze. But I've learned just to kind of start laughing and smiling. Because if you look at it in the big picture, happiness is the best revenge to anything. And it doesn't hurt anybody in the long run. At the time, my skin condition was a lot worse, and I was still in high school. Like I said, I have a hereditary skin condition that caused abscesses and cysts. And every day I would get told how disgusting I was for having this condition. I pretty much... they seep a lot when I sleep, and it would get on the sheets, and I would have to replace sheets, and they told me that I'm repulsive because of this condition. I had pretty much everything that broke at that house was somehow my fault. So I would be paying for vacuums and curtains and blinds. I'm trying not to cry, sorry, so I'm stuttering a lot, but it's just a lot of things go on, and the caseworkers, they visit, once a month, or the GALs. They don't really see how this kid is being treated on an everyday basis when the caseworker or GAL isn't in this home, because when they're in the home, everything's perfect, the house is flawless, at least from what they can tell. And then when I moved out, I found out that they cashed out my savings and my checks, so I had no savings account or money when I left. Along with some very expensive valuables and photos of my childhood. But like I said, it's really hard when you only visit once a month. I've suggested that they send in undercover agents into these homes, or like undercover youth at least, so they can see what's going on, like behind the scenes. So yeah, our next speaker is Rebecca Wallace, a staff attorney for the ACLU, and she is going to address the GAL's role in identifying and ending child abuse in facilities. Thank you. Keep reading on mic.
Thank you. Thank you for sharing that. Hi. So I'm a staff attorney at the American Civil Liberties Union of Colorado. My name's Rebecca. And I am not the experts on child law or child welfare in the way that the people in the room here are. I'm new to this area and only became involved in it because of our investigation into the use of solitary confinement at the El Pueblo Boys and Girls Ranch in Pueblo. I'm pretty sure many people in this room have heard about it. How many people have heard about that investigation? Okay, so I'm glad we're talking about it. And I have done what I can to become prepared to, understand some of the challenges that face GALs when it comes to doing things like investigating solitary confinement in a placement. So I've done my best to get up to speed on that, but I think what I hope I have to offer really is a set of experiences that the children shared with the ACLU and that ultimately turned out to be true about the use of solitary confinement in a state licensed residential treatment care facility. And I'm hoping that that I can give you some tips about how to identify that in the future and some ideas about ways the GALs can be involved in an investigation without compromising their ethical or legal obligations in what I understand is a very unsure legal landscape. Let me give you just a big picture overview, and then I'm going to ask you about you can think about this, any questions, issues, concerns that you have based on what you've heard about the El Pueblo investigation. I've heard from several GALs, and I want to make sure I address the issues that are here in this room. So the ACLU received a complaint about the use of solitary confinement at El Pueblo back in March of 2013, And we understood that DHS had received a complaint on this as early as November 2012 and had taken no action. So we felt a real sense of urgency. And we did a brief investigation where we found the allegations of the use of solitary confinement were credible, largely through interviewing children, but also some guardians. And we made a formal complaint to DHS and a demand would that they suspend the use of the reflection cottages and which is where the solitary confinement was taking place, and then investigate the use of that solitary confinement and end the practice. Within a few weeks, receiving our complaint, DHS opened that investigation. Within a few weeks after that, the reflection cottages were closed down, at least until El Pueblo can show that they can follow state regulations. There were clear findings of the use of prolonged solitary confinement on children in violation of state standards, denial of access to education, denial of access to recreation, denial of access to outdoor exercise. And we found that there were several children who were confined to their room 22 to 23 hours per day for days, weeks, and in a few cases, months at a time. So we ultimately were, at least at this point, successful. We're going to kind of see what happens as El Pueblo works through its new regulations and works with DHS to come into compliance. And, you know, we did try to work with GALs in the process, and frankly, it was very difficult. By and large, the GALs were uncomfortable with working with the ACLU, and I'll admit at the time that that was happening, I was personally very frustrated. As I've spent time talking to GALs and coming to better understand the concerns GALs had, I have a much better understanding of why many GALs were hesitant to engage in the investigation, and either with the ACLU or even independently. And my hope is that today we'll come up with some ideas and that you'll really feel confident that you can use if something like this arises again, where you have concerns about child abuse in a facility or violations of state regulations in a facility, and you're saying, what can I do and not be in violation of Title 19 and not be in violation of HIPAA, and how can I take action here? And I hope that I can give you some answers that you'll feel comfortable with. So let me just ask out here if there's any sort of questions, concerns, issues that you want to make sure that I address here. And I can just give you an example to set you off, which is I've heard, hey, the reflection cottages are good for some children. I have a child who was placed in them and they had good experiences there. Address that, please. That's an example.
I would like you to address how you obtained the records that showed what you just said, documented the long-term placements, because I have been trying to get those and they say that they don't really exist.
Okay, thank you.
I'd also like you to address what, if any, requirement of passing along information about the investigation El Pueblo was supposed to give to parents, because in my experience, they have told the parents nothing about the investigation or its conclusions.
Okay.
How did you get access to interview the children?
Okay. Okay. Well, I will do my best to address those. I think most of them, except for maybe the second one, will be addressed during the course of the presentation, and that there'll be time for questions at the end, and I'm hoping that there will be question and answer throughout, and I'll ask for input throughout. Don't hesitate, please, to interrupt me. So I'm going to give you a little more detail about the El Pueblo investigation, how it came to be. I mentioned that we got a complaint in March of 2013. That came from a public defender in Pueblo, and we were really her place of last resort to go to. She had complained directly to the Department of Human Services, both the big statewide department as well as the Pueblo Department of Human Services. She complained to caseworkers, a few GALs, and the judiciary, and she had gotten nowhere. The complaint with DHS had been sitting for 5 months with no action taken. This is not the ACLU's typical area where we work, although we work a lot on solitary confinement. We just don't usually work in a residential care facility, and we felt that we couldn't say no. So we began our investigation. Some of the children had parents who could contact the ACLU and say to the ACLU, I want you to be able to contact my child. And some of the children were over 15 and could make a choice to contact the ACLU. Sometimes we were trying to work with guardian ad litem to either give us contact information for the child, or to have the guardian ad litem give the child our contact information should he or she want to talk with the ACLU about their experiences, and should the GAL consider that to be in the child's best interest. In the end, we were able to interview about a dozen children, and we were able to find some corroborating evidence, not perfect evidence, for many of those children that they had been in long-term solitary confinement. Now, what do we mean by solitary confinement? Well, actually, let me tell you about corroborating documents. So we were sometimes able to get documents that would show how long the child was in the reflection cottages. We could also get documents indicating whether or not the child attended school. There were children in the reflection cottages who were attending school. They were not in solitary confinement. There were other problem children who were, and this is, I think, a small subset of the children at El Pueblo. And I guess I should make clear at the outset, the ACLU does not want to shut down El Pueblo. And the ACLU does not believe for a second that we know well how to care for and treat and bring to the next level at-risk kids who've been placed there. And so the judgment, there isn't like this fundamental overarching judgment. We've heard from so many GALs what an important role El Pueblo plays in provision of child care and child treatment, particularly because some of the kids who are at El Pueblo, if they weren't there, would otherwise be in detention. And we trust your judgment on that. But what we did have a beef with, and what we did want to end, is 23-hour per day, 22 to 23-hour per day lockdown of children. And what we learned from educational records, talking to children, housing records, and the housing records often reflected the reason the individual was placed in reflection cottages. We reviewed no mental health treatment records, nothing like that. And then also just from talking to the kids, from talking to guardians, and from talking to a few GALs, what we began to piece together is that there were many children, and we only talked to about a dozen, we're pretty sure there were more, who were put in reflection, some for very serious infractions, some for more minor, including mouthing off to a teacher. And we've reviewed records about one child who was in day school there, not even in the overnight facility, and then was kept for 24 hours overnight solitary confinement for mouthing off to a teacher. And we learned that the kids were placed in reflection cottages. This is what they look like. They're just a bare room with a concrete slab. Typically, that mattress was not there. The mattress was only provided at night when the child went to bed. And they were directed, they could not leave their room. They could not talk to other children. If they attempted to leave their room, many of the staff there would put their foot up against the door to stop them from leaving, or if they left their room while the staff were in the little office, the staff would come out and physically put the individual back in their room. Most of the kids took their meals alone in their room, and the kids that, I'm talking about a subset of children that were there, the kids we were focused on, they did not go outdoors, period. They did not get they did not get exercise. And they were also, for the most part, denied therapy, access to their, like the social workers that were on the scene, and they were not taken out of their rooms for education. Teachers rarely came to their rooms, and most of the education that they received was in the form of worksheets. So this is a subset of kids that were kept in that is what we mean when we say solitary confinement. And again, the ACLU doesn't take a position as to whether or not the reflection cottages might be used effectively, properly, within state standards. That may be possible for El Pueblo. We don't hold the knowledge to know how effectively those reflection cottages can be used. But we do know that they were being used in violation of state standards, and we believe in violation of the Constitution. So one of the things I just wanted to, I don't know how common it is, common knowledge it is, and I would imagine very common, that solitary confinement, prolonged solitary confinement is harmful, can be very harmful to kids, particularly at-risk kids. There's a number of studies that talk about the negative psychological effects of solitary confinement, particularly on mentally ill and developmentally disabled youth, including depression, anxiety, and suicide. The vast majority of young people at El Pueblo were developmentally disabled and or mentally ill. That is the focus for treatment for El Pueblo. So the use of solitary in that context is particularly troubling. Solitary confinement can also re-traumatize children who have experienced abuse and neglect in the past. These are two children that this is just talking about the harmful effects, but here we have two children that I personally interviewed. This is just two examples, and these are stories that I heard from them, and these are quotes that I took down that they told me on the phone when I just said, tell me what it was like being in solitary confinement. One of the children that I had talked to had been put in seclusion basically by their parents when he was a kid. And that's what he thought about when he was there. And my understanding, you will know this better than me, is that it's not an uncommon form of child abuse. So kids who are coming from abusive homes may well have been placed in seclusion in the past. And what we understand from the investigation in El Pueblo is El Pueblo did absolutely no individualized analysis about how is this kind of confinement going to affect this child? What is their history of trauma related to the use of solitary confinement? How can we provide them, even if we think they need to be secluded in some way, how can we provide them services from caring adults in their lives, like therapists, while they're still in a secluded environment? El Pueblo's practices plainly violated state standards, and I'll get to DHS's findings, but these are the quality standards for 24-hour child care, and it's pretty clear. The regulation explicitly prohibits seclusion of children except in emergency situations and only after all less restrictive alternatives have been exhausted. Children are supposed to be released from seclusion once the emergency passes, and except in the most extraordinary circumstances, they should be released within 2 hours. This is different from timeout. Okay, all the facilities, I don't know if all, but many facilities have timeout rooms. And it's certainly possible that facilities can safely and appropriately use seclusion. We are talking about days of isolation for children. And for a variety of reasons. I mentioned that they were getting secluded for some for serious infractions like trying to run, others for more minor infractions like mouthing off on a teacher. We also learned of several cases where individuals who had communicable diseases like scabies that they had caught in the facility were placed for days in solitary confinement. That is an inappropriate use of solitary confinement. Those individuals could be placed in a form of isolation with a medical care provider, but certainly not in what feels to those children like punitive isolation. These regulations are codified in the Colorado Code of Regulations, and so I've discussed already what we saw happening with El Pueblo. We saw a use of solitary not infrequently. One of the important things we noticed is that parents and guardians, by the regulations, are supposed to be contacted when an individual is placed, when a child is placed in solitary confinement. What we learned from talking to the guardians, it was very spotty. Sometimes El Pueblo contacted the parents, sometimes they didn't. Perhaps of more concern, when parents who were concerned about their kids' placement in the reflection cottages came to visit, El Pueblo consistently refused to allow any parents to see the reflection cottages. I'm not surprised given the photo that I showed you earlier, but that's what occurred. So I told you that after about a month of investigation, we sent the demand letter to DHS, and we did so with publicity, and that wasn't a stunt. We at the ACLU are very careful about whether or not we utilize publicity, and we always do it because we think we can get the best result with or without it. If we think we're going to get a better result without publicity, we will do it that way. In this case, we felt we had absolutely no choice, given the wide number of people at DHS who had already heard about this issue and had chosen to do nothing. We felt we had no choice but to do it with publicity and to hope that public pressure would increase and lead DHS to take action here. That worked. And I should note, even before DHS initiated its investigation, a couple weeks after we sent the letter, I got a call from the El Pueblo School Board, a member, who said, I'm really concerned about about what I'm reading has occurred here. And I connected her with guardians and their children who had given permission to talk with the school board, who could talk about their experiences and share the documents that they had, that they don't perfectly reflect solitary confinement. It's the combination of they were in reflection cottages for 2 weeks, they had no educational records, and the child is telling us that they weren't permitted to leave their room, and there's no indication of recreation. That's the whole combination of factors. And we connected these individuals with the school board, and as a result, the school board took a vote, actually the next day, to suspend the use of the reflection cottages in their contract with El Pueblo, meaning that all the students that were being placed in day school at El Pueblo was not placed by the Pueblo School District. El Pueblo was not permitted to put those individuals in reflection cottages. So we were so delighted when that happened so quickly. Within about a few weeks, here's the timeline, the DHS initiated its investigation. And to DHS's credit, they were very transparent with us throughout the entire process. They went out to El Pueblo, did an initial investigation. We gave them names of people to investigate, and within a very short period of time, were able to confirm the improper use of solitary confinement. What they didn't know was the scope of the problem or the breadth of the problem. So DHS requested El Pueblo voluntarily suspend the use of the reflection cottages temporarily, which it did. And 2 weeks after that, DHS issued a report, which I'll review the highlights of, but confirming that, that El Pueblo was in violation of state regulations and suspending the use of the reflection cottages until El Pueblo could show that it had come into compliance. So I just want to review a few of the DHS's findings. This is the finding that youth were being placed in solitary confinement in violation of state regulations. Specifically, DHS found that children placed in the reflection cottages, some children, were prohibited from interacting with others and had little, if any, clinical intervention. DHS reviewed all the records, so they had access to records we didn't have, and found that on several occasions, children were secluded for 24 hours a day. They did not leave their room except for to go to the bathroom or shower, and some for between 7 and 14 days. We also have found we found 2 children that were there for over a month. A really important part of DHS's findings, and I should say we've included the entire findings from DHS in your electronic materials, is that children were not being provided adequate educational programming or recreation when in the reflection cottages. Again, we spoke with and reviewed records of many children who had been denied education for weeks and sometimes more than a month at a time. DHS also found that El Pueblo's physical management policy was not compliant with current rules and that a staff member's certification had expired. Some of the really interesting, sad findings that DHS found, to really reflect the use of solitary confinement, where the wear marks on the windows and on the doors, where kids had spent hours and hours leaning up, pressing up, or scratching in at the windows and the doors of their rooms. They saw there were 15-minute checks that El Pueblo was doing, and it would be check after check after check showing that a child had not left their room, was not engaging in violent behavior, was not getting education, was not getting therapy, was just sitting in their room, hour after hour after hour, and sometimes day after day. One thing that I'll note is not only are these kinds of findings show violations of state regulations, from the ACLU's perspective, this raises serious constitutional concerns. There's a 10th Circuit case, Malonis v. Williams, that recognizes that children placed at state-licensed residential child care facilities retain substantial liberty interests not to be confined unnecessarily. This was about a Utah state-licensed facility that used isolation rooms. And the court found that the use of these isolation rooms for any reason other than for a boy who is violent, to contain the boy who is violent, violated the due process clause. And that was where kids were being held only for 24 hours, so much shorter periods of time. I think when one considers that El Pueblo really focuses on developmentally disabled and mentally ill children, that the concerns of due process violations and harming the child are really much greater. So, let me see where I am here. So let's talk about the GAL's role in the El Pueblo investigation. We reached out to several GALs and sort of asked for a variety of things. We said, can you give us records related to your child about their housing records? Could you tell us whether or not you know the child was held in the reflection cottages? Could you connect us with your child either by giving them their contact information or by giving the child our contact information? You could be present on the phone call. We want to engage in this investigation. We have credible allegations of abuse, and for many of the children, they were in state custody, and there was really no one to go to but the GAL. The few times we were able to reach out to caseworkers, the caseworker always said, go to the GAL. And by and large, GALs did not work with us. And I was thinking maybe you all could raise some of the concerns that you think GALs or you might face. You know, when someone like the ACLU comes and says, we've got allegations of abuse, we want to talk to your kid, we want to review the records. Would you be concerned about handing over the records or letting the child talk to the ACLU? Because lots of people were. Okay, I'll tell you some of the things that we heard. Oh.
Kids were placed in Pueblo or other counties?
We were talking to more than just Pueblo kids. We had an El Paso kid and a Denver kid also. Mostly kids from Pueblo. Well, some of the concerns that we heard that I think, as I've come to understand better, GAL's role, that I think are very valid concerns, is we heard concerns about confidentiality, Title 19. We heard concerns about HIPAA. We heard concerns about whether the GAL was a person authorized to disclose these records or release records or sign a release. We heard concerns about whether or not doing so would be in the best interest of the child. And like I said, at the time it was pretty frustrating, but I've really come to understand, respect, and have sympathy for the complicated position GALs are in this kind of circumstances. The law in the area is highly unsettled. We know the governing statutes are sparse. The CJD does not provide much additional guidance. There's little case law addressing the specific contours of the GAL's duties and authorities. And many GALs who I talked with after this incident talked to me about feeling like the stakes were really quite high. That a GAL who is found not to be serving the best interests of the child may jeopardize her contract with OCR. She may be sanctioned to professional conduct standards for violating some form of confidentiality, or even a fine under Title 19. So it's not surprising that GALs would be reluctant to engage in, to take further steps absent sort of clear authority to do so. Still, I'm here, really saying that yes, the law is unsettled, but that GALs cannot be so hamstrung by the unknowns that they do nothing when faced with credible allegations of child abuse in a child care facility.
Did any of your GALs undertake an independent? I'm wondering if any of your GALs undertook an independent investigation for their specific child or children that they represented. Typically, you would only have one down there.
I can't say that I know for certain, but I think I have it on pretty good authority that no, they did not. Whether GALs, whether any of the GALs that we spoke to, and there may have been GALs that we didn't speak to that did this, engaged in an independent investigation of the use of solitary confinement at El Pueblo.
For their particular child.
For their particular child. So from my knowledge, and there might be GALs who have something different to say about this, certainly no GAL said, I'm going to look into this. In fact, we had trouble getting GALs to respond to us and hear the full extent of the allegations. But this is not, I feel like over time, I get this. I get what was happening there. And I also didn't know, I get why a GAL would hear, I want to see records and think, whoa, 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 I don't know this person from Adam, number one. I don't know that this is good for my child. My child's no longer in this placement. Really, what am I doing that's good for this child? So this is not a, get upset with the GALs who may have felt uncomfortable getting involved. This is what can we do? What can we do? We'll talk about, these are things you know well, so I'm going to go through them quickly, sort of the outlining contours of the GAL's role. We know that the GAL's client is the best interest of the child, and that a GAL must independently evaluate the child's best interests, and I'm taking this from the CJD, diligently take steps that he deems necessary to represent and protect the best interests of the child. I know that it must be frustrating that Colorado has not provided much guidance as to what constitutes the best interests of the child. But that also seems to support the concept that GALs do in fact enjoy wide discretion when asserting and identifying the best interest of the child, that a GAL should feel confident relying on intuition and past experience when making a determination about what constitutes the child's best interests. Also surrounding this is the unique relationship between the GAL and her child. That, the duty of confidentiality in terms of the attorney-client privilege, I know you all know, doesn't apply in a standard way. That a GAL may, in fact, release information in a limited way when they view it as in the best interest of their child, without violating attorney-client privilege. We still haven't dealt with Title 19. And one of the most important points, I think, is that Colorado law imposes on the GAL a duty to independently investigate allegations of child abuse in a facility where a child is placed. The CJD requires that GALs investigate each placement and that they, quote, continue to perform an ongoing investigation as necessary to represent the best interests of the child. So, in our view, it's clear, and I have to say, after talking to GALs, I think there's agreement on this, that it's clear that an independent investigation is within the scope of the GAL's authority, and it's an integral part of the GAL's duties. To the extent people here disagree, that's okay. We have some ideas of how to work with, hey, I'm concerned this isn't within my authority, that we'll talk about. Now, one other sort of broad-based contour I want to point out before we get into what specifically can I do is LAN. Now, that is not on point for these circumstances. This case is not about the this is not about the psychotherapist-patient privilege. It wasn't about mental health records. LAN addressed the question of who should hold a child's psychotherapist-patient privilege. I'm sure you guys are sick to death of talking about LAN. In a dependency and neglect proceeding when neither the child nor the child's parent is able to do so. The court reasoned that the Department of Human Services should not hold the privilege, basically because DHS has skin in the game. It's got the duty to diligently bring its DNN case, and that may cloud DHS's ability to further the best interests of the child. LAN also held that the juvenile court was not in the best position to hold the privilege because of the court's role as an independent decision maker bars it from advocating on behalf of the child's best interests. So ultimately, LAN made an important conclusion that I think is relevant in this context. It concluded that the GAL was in the best position to hold this privilege for many of what I believe are the same reasons that a GAL in the El Pueblo investigation had an important role to play, particularly when the child was in the state's custody. So the court found that the GAL's statutory duties to represent and protect the best interests of the child those unique duties ensure that the GAL would not reveal privileged information if doing so would be contrary to the child's best interests. More broadly, the court's opinion suggests that the GAL is uniquely situated to understand what is truly in the child's best interest, and thus the GAL is uniquely situated to make decisions which would further the best interest of the child. Which gets me to the, if not the GAL, then who? There was no one else. There was no one else to go to under these circumstances for kids who were in the custody of the state. So I have some views after having talked with many GALs about why doing something, engaging in some kind of investigation, maybe allowing the child to speak to an attorney might be in that child's best interest, or not. And I'm wondering if anyone here has thoughts about why you think it would or would not be in the child's best interest to engage in, to allow that child, for instance, to talk with the ACLU about the allegations of solitary confinement at El Pueblo.
On the one hand, it could be therapeutic for a child who's upset about the way they were treated to talk to someone about it, but I don't know if getting involved with the ACLU and publicity and newspapers and having that kind of exposure and potentially being brought into court for a child that's already been traumatized is ideal.
So what I just heard was it may be therapeutic for the child to be able to talk about these issues, but maybe not in the context of lawyers and the ACLU and publicity and possibly a lawsuit.
We have a question up on the balcony. I'm wondering if you could just have it shouted down. Oh no, that's glitter and that's fine. I can wait.
I'll bring it. Well, I guess as an initial matter, I'll say that if what is happening is the GAL is taking in all of the information and ultimately making a decision, this is not in the best interest of my child, that's just legitimate. That's all there is to it. That wasn't the experience that we had. We didn't have open and robust discussions about what it would mean to be involved. And I think there were some GALs who really wanted to investigate and didn't feel they personally had the capacity to do so, but felt that there was no one else to turn to. And so we were able to make assurances about, for those GALs who wanted it, assurances that there would be no publicity to the child, that the information would be kept in confidence, that it would only be used in the form you saw it if the child and the GAL agreed, and which is, just with the child's, child 1, child 2, that there was no promises related to a lawsuit, no pressure to engage in a lawsuit, that the primary goal was to end the practice, and that the interview with the child could happen with the GAL present. I would have agreed to have the GAL ask the questions. I would have had no problem with that. So I think there'd be many ways to think about working together to solve those problems, or, again, it all comes down to if you truly believe it's not in the child's best interest, that's the end of the analysis. Any other thoughts on that?
I was contacted by ACLU on this matter, and I believe my kid, El Paso County kid, was the one in your case. So I will tell you, when I was first approached by email about this matter, I deferred to his mother. Mm-hmm. He has an adopted mother who has been very involved. We have never had a question of her unfitness. He is developmentally delayed. He has severe mental health diagnoses. El Pueblo had historically been the placement that was able to stabilize him. Mm-hmm. Any other placement we ever attempted with this child went terribly wrong, resulted in delinquency charges, resulted in him possibly losing his life. The one time, the year prior to this, we tried to step him down. He ran away from the group home, throwing himself into heavy traffic. Very, very dangerous situations. His needs are so high. He's been in and out of the state hospital. He has this history. His mother has been extremely involved. She has always supported him, always. I felt, as GAL, the DNN was open for his reasonings, his needs to be safe and stable. I wanted to defer to his mother. Never would we intend on terminating her rights. She has always advocated appropriately for her son. I did not want to usurp her parental rights at all. I wanted to support her through this. So I deferred to her, and I said, if you need me further, please let me know. Of course, as you mentioned, I felt like I did not have the full capacity to do my own investigation alone. I do have a social worker on staff who helped me out and went down and did some interviewing and did some gathering of information, and his work was very helpful, and we just followed along with the ACLU action and the DHS investigation that was going, and felt it was meeting his needs. Unfortunately, then there was a turn of events in his life, and he's because El Pueblo stopped using the reflection cottage, he did wind up back at the state hospital again in the locked adolescent unit for a very long time. He picked up multiple delinquency charges while at the state hospital. It became extremely a volatile case. So then I got involved more with what was going on in Pueblo. Luckily, there was GAL appointed on his delinquency cases in Pueblo also, and she was very helpful as well, and now he was transferred, and he's in the BTU unit for adults at the state hospital. And the district attorney decided to drop all the delinquency charges to allow him to go get that treatment. His mother made these choices. We wanted her to make the choices and the final decision. I supported the Attorney General coming in on this case, helping us out to get him where he is today. So it's not, and perhaps I did not follow through enough with my own investigation, and maybe I didn't do quite enough, but I did stay in touch with what was going on, and things got so volatile with his case after that, so it's just, it's a hard place to be, especially, and I'll tell you, I wasn't resistant, and in my email to the public defender in Pueblo, and also to whoever she copied, I'm not sure of the name, from ACLU on those emails, I said, contact me further, but I defer to this mother. And I think I'm still right in that decision. So.
Absolutely. First of all, thank you so much for sharing that. And second, I mean, I don't want to point people out, but I'm not talking about one person individual. I'm talking about an array of experiences we had. And certainly deferring to the mother, over and over again, we were delighted when we were dealing with a child who had a parent, because then we could go and reach out to the parent. So that was a wonderful situation for us. And the really complex ones that really seem to, everybody stumbled upon, is what do we do when the child has no, is in the custody of the state, and the state is not really in a position to police itself and its own placements. So what can we do? I wanted to bring up several, people are going to have a variety of ways to analyze what is a breach of confidentiality, what is in the best interest of the child, how far should their investigation go, and I think that there are a wide array of conclusions that GALs can come to, including the one that was just spoken about here, that are absolutely reasonable. So what can we do based on what our conclusions are? Yes?
Rebecca, just because the OCR was alerted to some of this, I want to raise a couple of other questions GALs had, because I think they were important. Some GALs were being asked, at least our understanding from talking not to you but the public defender, to sign releases of the records. So that was one issue. The other issue GALs were being asked is maybe they could get some records from the department and then pass them along to the ACLU investigators, and I think that GALs felt uncomfortable playing that sort of role as well.
Absolutely. So what could GALs do? Let's talk about it. And this is not what could GALs do historically. It's what can GALs do when they're faced with this in the future. I mean, I know that this is additional work, but I believe it's based on the GALs that I've talked to. This is the work you want to be doing, which is, one is, file a notice of institutional abuse. Begin that process. And if there are multiple GALs filing that, that could be more likely to get attention. AGALs are not mandatory reporters under Colorado law, but they're certainly reasonable people to file a notice of institutional abuse and protect the best interests of the child. Something else that a few JALs have suggested, and one has done, is stipulate to conditions of placement at child care facilities. A GAL could stipulate that a child is not to be placed, if the GAL believes this is in the child's best interest, that a child is not to be placed in seclusion for an excess of 2 hours without contacting and getting approval from the GAL, or if the GAL doesn't want that responsibility, then simply no more than 2 hours, which is essentially complying with state regulations. A GAL can recommend to the court that the court appoint a lawyer for a child to address this issue. The GAL doesn't feel comfortable working with the ACLU, but sees that there's a real issue here. The GAL doesn't feel comfortable or doesn't have the resources to do their own investigation. They go to the court and they ask for the court to appoint a lawyer for the child. And this is, we believe, is supportable under CRS 1319-102.
Rebecca, I'm sorry, I just want to interject one
Yeah.
other thing from the OCR's perspective. In terms of this idea of limited resources to investigate the individual best interests of a child, I want to emphasize that this is time the OCR wants to pay you on. If you believe you need an independent investigator, that is something you can seek pre-approval on. I think part of this was pitting the resources about investigating broad institutional abuse allegations, which is very different than looking into your own child's experience at a facility and how that's impacting your advocacy, and we will give you the resources you need to do that.
Doing your own analysis as a GAL to think about what is in the best interest of the child, the GAL could inform the child that the ACLU is conducting an investigation and would be interested in talking to the child about their experiences, and then give the child the contact information for the ACLU if you determine that's in the best interest of the child to be able to talk about this. You could do that in a limited way and say, I want to be present for the call, or I want to ask the questions and the ACLU can listen. And that's going to be an analysis you'd have to do about whether it was good for the child to engage in these discussions. I'm not a specialist in this, but I can say it felt to me that the children that we spoke with felt good about having an ear about the problem they were experiencing, and then felt good to hear that their speaking about a problem they were experiencing resulted in change rapidly. That is your own individual determination. But you'd also want to think about access to the courts and access to representation and hearing the child's voice in that. You may also if you speak to the child and the child's comfortable with speaking to the ACLU and you believe it's in the best interest of the child, you can give the contact information for the child to the ACLU. Again, you can say to the ACLU, you can only call them if you're going to call me as well. We'll talk at the same time. You can help the child who wants to be involved in this communicate his own concerns to the court. You can help them do that. You can report allegations to human rights organizations. One of the things that is probably the most time-consuming, but for those who are most concerned about all this variety of issues, like the sharing of records because it might be a violation of, because it would be a violation of Title 19, and we'll talk about a little more about that in HIPAA concerns, although I don't think HIPAA actually applies. You can always petition the court. And I don't know GALs well enough to know whether that's an eye-rolling suggestion or a good suggestion from the perspective of most people. I have talked to GALs who have done this, so it's certainly not crazy. Yes. Okay. You can go to the court. You can ask the court to direct that the child not be placed in the reflection cottages. You can ask the court to do an external investigation. You can ask for advice from the court about what are the scope of my duties in a case like this. I have a child who's no longer placed at El Pueblo. He might have been subjected to solitary confinement. Is this in the scope of my duties? He might get placed there again. You can ask for an expansion of duties. You could ask for a court to authorize you to sign releases on the child's behalf. You can ask for permission to cooperate with an external investigation into the child abuse occurring at the facility. Now, when we're talking about HIPAA has come up before, I don't know how clear how much everyone knows this, I'm betting you know it better than me, but HIPAA only governs behavior of covered entities. GALs are not covered entities. And so it really doesn't apply in this context unless records are being requested from El Pueblo directly, like the ACLU wants El Pueblo to give them records. And regarding Title 19, which is certainly the most constraining of all of the issues, is GALs may still be able to have conversations with the ACLU to confirm information about an individual. Like if the child shares individual about solitary confinement and the GAL has, through other conversations, had confirmation that's occurred, they may be able to share that. But to the extent that the GAL is concerned that passing any information on to an investigating organization like the ACLU violates Title 19, there's a provision under Title 19, 19.1.307, that supports the idea of going to the court for a court order to allow release of information for good cause. And that includes protected information that was gathered. It's very broad language so that a GAL could legitimately argue that a reputable external investigator such as the ACLU qualifies for access to information under that rule, and then there'd be a court order in place. In effective investigation techniques, I just want to talk quickly about this. To think about when you're going into these facilities to really, really dig deep and ask a lot of probing questions to the child. Ask to see where they are sleeping, like actually look at it. Ask to see where they are receiving education and ask them how many times that week they have been to school and for how long. Ask them, do you go outside? Where do you go? Ask to speak to their therapist. Find out when their therapist last spoke to them. These children were being denied access to therapy. Ask them how long they're in a room by themselves. There were wonderful GALs who didn't know that this was happening, and the children weren't like, alert, alert, I'm in solitary confinement. They didn't know, they were just being punished. And so, my conclusion, and I hope that this has been empowering more than it's been an exercise in defensiveness, because I could never do the job that you guys do, and I have total empathy is not the right word, because I sympathy for the position that many of you are in when faced with these kinds of complicated questions, but that GALs can do something, that you can trust your intuition and your experiences, and you can go to the court if you need to, and when it comes to kids in state custody, if not you, then who? Thank you.